Whatever, I'll save it. It's not all that big a deal.
Good morning, everyone. We have a very full day ahead of us with some pretty weighty topics. So we're going to start the morning learning about consumption taxes. That's really our only 201 of the day. And then we're digging into some real substance with the tax expenditure report with Patrick Titterton, and then a review and update on some the income-based education tax study and study committee update, which Representative Beck and I spent a significant portion of our fall working on. And then at 2 o'clock, we are joining a joint presentation to hear about the findings in the RAND childcare financing study. It's going to be a 1 hour presentation that all six relevant committees are going to Zoom into. There won't be an opportunity for Q&A. And then the study authors are going to join each committee separately so we can have Q&A that's really focused on our legislative purview. So take notes about your questions when we're in there. And that is the delightful full day we'll have before we go to the floor. Any announcements or thoughts that anyone?
Well, this is neither here nor there, or maybe or something, but I know.
I love it when people preface things with that.
There's some complaints about some press that they were closed out of meetings, but in fact, since these are all live, they can hear everything we say at any time, right? So.
Sure, I do think it's important that press is allowed actually fully into the room. And my memory of what happened in the committee room was that I said a few times, would anyone other than the press like to leave the room?
You did say that.
But I think that maybe some press, we didn't realize that some folks were press because they don't wear hats. There's no way of knowing, and they know what we look like, but we don't necessarily know what they look like. So, but I'm going to revisit some policies over the week to figure that out.
My sympathy, but they weren't closed out.
We're going to figure it out over the course of the week to make sure that everyone has access to our proceedings that needs it while we maintain our safety. And with that, thank you, Jim, for the vote of confidence. Consumption taxes. All our presentations are up on the website. If you can't find them, refresh.
Thank you. So good morning to everyone. For the record, Abby Shepherd, Office of Legislative Counsel. This is under my name. It is the sales and use tax and meals and rooms tax overview. I am really focusing on the two main tax types that I work on. There are other types of consumption taxes, but I'm going to really focus on what this committee has done for these two tax types in the past. So to jump right into it, I do just want to say there have been some questions about sales tax in particular. I'll try and address those, but if I don't, or if you have additional questions, please feel free to interrupt me, and I will try to answer your questions if it's something I've dealt with in the past. Otherwise, I will get back to you. So we'll look at these two types, starting first with sales tax, and then we'll move on to meals tax. So I'm breezing right through the slides. I'm on slide 3. I will look at the structure since we did have that anatomy of a tax presentation. I'm trying to break each of these tax types down into those 3 parts so you can see how they are structured. I will go over 2 fairly significant recent changes, recent in the last 4 to 5 years, Quill and then the Wayfair decision, as well as marketplace facilitator laws that came shortly after Wayfair was ruled by the U.S. Supreme Court. So moving on to slide 4, the sales and use tax as its tax base uses retail sales of tangible personal property and other enumerated charges or services. Typically, what you think of when you think of the sales tax are goods, so it's a tax on goods, but Vermont does tax some other types of charges, some very specific services. So you might hear people say Vermont doesn't tax services. Generally, that's true, but there are some services, charges for entrance to places of entertainment. There are some online services and streaming that are subject to sales tax. So there is some nuance there, but generally services aren't taxed in Vermont. I have provided, again, some of the statutory references here. And then I also have many exemptions based on a variety of different reasonings and policy choices. It could be an exemption for a specific good. It can be an exemption for the purchaser. It could be an exemption for the seller, transaction, or use. There are actually 3 different sections that set out all of the different exemptions. There are over 50. I think we're pushing maybe 60 at this point. So I know you will hear later about tax expenditures today, so you'll get a even broader overview than that on different sales tax exemptions. As I'm sure you're all aware, it's a flat 6% rate. I do not go into detail on the local option tax in this, but there is also a local option tax of 1% on the state sales that are subject to state sales tax. And the liability is on the final purchaser. Although it is considered, these are both what we call trust taxes or consumption taxes, because the seller is collecting the tax from the purchaser and then remitting it to the state. So the seller is actually liable for the tax under statute because they're holding it in trust for the state. Oh, sorry, I'd go on to talk about that in a little more detail on my next slide. Paid by the purchaser. Oh, also an important point. It is on retail. It's not on wholesale. So this is different from excise taxes. That is within the imposition of the tax statute. And I'm pointing this out and emphasizing this because resales, for example, and subleases, those are not subject to sales tax. So we say it's an exemption, but really it's baked into the way that the statute is written that sales for resale are not subject to sales tax. Again, these are held in trust. It's the seller who's collecting and is liable under statute. And I do also have in bold, sales tax is paid on retail sales, and in Vermont, use tax is paid when the purchase is outside of the state, but the product is being brought back into Vermont for use in Vermont. And that's where the Wayfair decision and previously Quill were so important in Vermont, because that was limiting who Vermont could require to collect tax on and on what type of transactions. So as I did mention, there's a 1% local option tax. It's when a retail sale is subject to the state sales tax. A municipality can impose that 1%, as we discussed last week. Moving on to slide 6.
I have a question.
Yes.
Which is a slightly random question, so I'm sorry. If there is interest on taxes held in trust, is that interest the property of the person holding the taxes in trust, or the actual ultimate owner of the?
So most sellers are required, and I don't know off the top of my head exactly what the threshold is, but most sellers, if they're making over a certain amount of taxable sales, are required to remit monthly. So they wouldn't be holding the funds in trust, but there are very, very small sellers that can remit annually or quarterly. I can look into that. I don't know that the statute contemplates interest. That's an interesting question.
Thanks.
So moving straight into the constitutional questions behind sales tax and what has changed recently, because there has been this is an area where there was significant federal changes that have changed the way that Vermont can collect sales tax and have had a direct impact on Vermont's revenues. So under the U.S. Constitution, a state's power to tax is limited by the Commerce Clause in particular, which reserves to Congress, to U.S. Congress, the power to regulate trade or interstate commerce among the states. And under that Commerce Clause, a state cannot tax goods that are in interstate commerce, so in between states, in a way that discriminates against interstate commerce, so in favor of intrastate commerce, or that imposes an undue burden on interstate commerce. And these are 2 important points within that Commerce Clause that Quill and Wayfair specifically discussed. And that is actually one of the questions that I wanted to answer about Wayfair's impact on Vermont's collections from remote sellers. Moving on to slide 7, back in 1992, so just predating the internet, an office supply company called Quill was soliciting and selling goods in North Dakota via U.S. mail, so by catalog, but Quill had no physical presence in the state. North Dakota sued the company Quill to collect and remit use tax for the goods that were being purchased in the state for use in the state. And under the Commerce Clause, the US Supreme Court ruled that a state cannot force a seller to collect and remit sales tax in that state unless the seller actually has a physical presence. So online retailers later, when there was the internet, online retailers who were making sales into a state but lacked a physical presence, they were only soliciting sales, they weren't actually physically located there, were not obligated to collect and remit sales tax in that state or in any of those states. So as online sales increased as a proportion of all sales, this really gave online retailers a competitive edge over brick and mortar stores. And through the early 2000s up until 2018, when Wayfair was handed down, this was sort of the perennial issue. Many of you remember this very well, I'm sure. I've had many presentations on this particular issue. So in 2018, the US Supreme Court did hear a challenge. Well, take a step back. South Dakota, I think in 2016, enacted a law directly in conflict with the Quill decision. And that law required any vendor, regardless of whether they were physically located in the state, to collect and remit sales tax if that vendor was annually delivering goods or services into South Dakota that were either more than $100,000 of sales or 200 or more individual transactions. So there was a threshold there to exclude very small sellers. This then prompted several online retailers, including Wayfair, to sue to invalidate the law as unconstitutional under Quill and the Commerce Clause. But it did make it to the US Supreme Court, and the justices ruled that in light of developments, particularly with online sales, the physical presence requirement of Quill was incorrect and unsound. So they overturned the previous precedent. Their conclusion was that South Dakota's economic presence, so that $100,000 of sales or 200, but not both, 200 transactions, that was not an undue burden under the Commerce Clause. They specifically noted that South Dakota still is a member state of the Streamlined Agreement, like Vermont, which is this multi-state sales tax agreement, which reduced the compliance burden on sellers, particularly smaller sellers. So that was one of the questions that came up. I'm not sure if I was testifying, but last week there was a question about whether Wayfair has made Streamline less relevant to Vermont's collections. In fact, my interpretation is fairly clear. What the Supreme Court said is that this agreement does show that in addition to the economic presence test, those 100,000 or 200 transactions, that actually there is no undue burden on smaller businesses and on interstate commerce. So not that that's a requirement in any way, but it's one factor in looking at the constitutionality of requiring remote sellers to collect.
Yeah.
So to the question, does that make Streamline, in your opinion, more relevant or less relevant, given all that?
My interpretation is that it is more relevant and that it is not a requirement by any means, but in addition to the economic presence threshold, does put Vermont in particular on solid ground like South Dakota, because we're in a very similar situation to South Dakota's law.
Okay, thank you.
There may be other policy reasons not to, but in that particular circumstance, the justices were very clear and specifically called out Streamlined.
Yes.
I'm sorry, but can I get just a 1 or 2 sentence description of what Streamlined Agreement is?
Certainly,
please?
yes. So the Streamlined Agreement, Vermont became a member in 2007. It's between multiple states and it provides model definitions for statute and interpretations of those definitions. And try to think of an example. I think Emily actually brought up this example. So food, for example, is exempt under Vermont's sales tax law. The way it's defined, we follow the streamlined definitions. They don't have to be exactly precisely the same, but that provides a whole set of, it provides precedent, or that's not quite the right word because it doesn't have any like judicial authority over Vermont, but it provides certainty and predictability for sellers. They know this is what candy is, this is what food is. That said, as Emily pointed out in one of her presentations, candy excludes anything with flour. So that leads to more complexity. As with any definition, you get into more complexity. There are several different software vendors that provide collection services to sellers. So when you're part of a streamlined agreement, it's, I don't know if to say easier, but those software companies already have everything set up for streamlined states. So it's to help with compliance and uniformity across states. And it's specific to sales tax.
I think Rep. Maslin was next in the round.
Yeah, maybe not for today, but for subject, when we get back to this sort of thing, is there's times when this committee is considered tax candy. And as we know, there's a definition
Yes.
difficulty. And so I just like to put that on the list of things that we bring up at the appropriate time. In my personal opinion, candy is certainly not food. That's my short version, but we'll get to it when we get to it.
Sure, imagine it's going to come up at some point. Rep. Anthony and then Rep. Bodie.
I don't know if it helps, but one of the explanations for keeping streamline that was presented to me is the feature of the Supreme's thinking about discriminatory intent or effect. And notice if a whole bunch of states, if you will, comply or comport with the same protocol, it sort of takes the teeth out of the allegation that you're being discriminatory, for what it's worth.
That's a great point, and that is that other prong of the Commerce Clause.
Correct.
Test.
Yep.
Yes.
Rep. Bodie, did you have something?
I did, thank you. When Amazon and other online sellers are collecting the sales tax, do they immediately remit that to Vermont
It would be on a monthly basis.
monthly for Amazon?
Monthly, because they're quite large, so they're surely exceeding the thresholds. I will get into the marketplace facilitators, because that's slightly different. That's within the same, they're the same thresholds, and it's within that same logic of if you are making sales into the state, even if you don't have a physical presence, who has the liability to collect and remit? And I will get into that in more detail in 2 or 3 slides.
Maybe you don't have the substantive knowledge to answer this, but I would think that Amazon could immediately send with their computer systems and software systems.
Oh,
Immediately get that.
yes, I don't know about the ability, just the legal requirement is a monthly filing.
All right, thanks.
Back to you.
Okay, thank you. So Vermont did anticipate Wayfair. Since 2007, Vermont has been a member state. There are different levels. There are full member states, partial member states. Vermont is a full member state, which means that we do have 2 delegate positions on the governing board. The governing board thinks about things like what are the definitions, how should interpretations of the definitions be made. Vermont is a full member and has a legislative and a administrative delegate. So in Act 134 of 2016, so 2 years before the Wayfair decision was handed down, but around the time that South Dakota did enact its sort of challenge law to Quill, Vermont created its own economic presence requirement, the same as South Dakota's, and included an effective date if there was federal. There were also several bills federally, sort of perennially proposed to overrule the Quill precedent and make remote sellers required to collect in every state. Those never passed. So instead it was through the court system that Quill was overturned. The contingent effective date was the first day of the first quarter after Quill was overturned, which just the way that the ruling came down, it ended up being several days after the ruling. So collection began officially July 1st, 2018.
I'm seeing the $100,000 or 200 transaction sort of threshold, and you may not know the answer to this, but do we have a sense of which one is triggered more often? Is it the 200 transactions or the 100, or do we find that they're sort of roughly equivalent?
I'm not sure, and I don't know, that might be a good question for the tax department. I don't know that there is reporting on the sales tax returns that would require a seller to say that. I think it's triggered and they're expected to collect and remit. But I could follow up with them to see if they have any information on that.
And I remember hearing about all the education efforts that we do. Do we do auditing?
Certainly, the department has auditing authority. So it's all, this was one, it looks small when you see the legislative language, but it was one new definition within the sales tax chapter. All of the same auditing and all of the same authority the department has applies to these sellers. So they become, it was a change to the definition of a vendor, and it said, even if you don't have a physical presence, if you exceed this threshold, you're a vendor, you are liable to collect.
I guess just seeing that 200 strikes me as like kind of low. That's like 16 transactions a month. But anyway, thanks.
Other states have, and I don't know off the top of my head what they are, but other states did do slightly higher thresholds.
Representative.
Yeah, when a business finds itself in this 100,000, 200 transaction bucket, are they required to file a report with the state of Vermont and then they say, but we didn't meet these thresholds, or do they just not report at all?
I'm not sure, I would have to check. Once they've triggered it, they have to get a sales tax license number, all of that, so they're in the system.
Yeah.
But I don't recall how you have to continue to file and just say no sales. I can follow up on that.
Because in Vermont, I mean, you could be a business in Vermont selling all kinds of stuff and have it all be non-taxable, but you still have to file.
Fairly certain you still have to file, because there is a box for non-taxable sales as well. There's reporting all gross receipts and then taxable receipts, so I will follow up.
Okay.
That's an interesting administrative detail, but in terms of getting the data, that means there's more data on
Right.
who is a seller in Vermont.
I'm really interested in the contingency effective date as just sort of a legislative mechanism for legislating towards the future. I wonder if you could talk a little bit more about that mechanism. So I think it's something we don't see very often.
Oh, actually, that's one
I
of
know that we made a lot of money because we had this effective date.
both of these issues. I think it was the click-through nexus as well. The year prior, there was another Colorado case, Roll, I think was the name, that also had a contingent effective date, knowing that there was a pending US Supreme Court decision. So it is possible. So I might need to confirm this by looking at some of our internal memos on vagueness. So there are constitutional requirements with contingent effective dates that you have to have some level of certainty. It can't just be at some point this will kick in. So I think that's why in this particular instance, it was either federal legislation or a controlling court decision abrogates the Quill physical presence requirement, and then it had a set date. And it was also on the later of, what year would that have been? 2016, July 1st, 2016, or when this is federally superseded in some way. So there are some, to make it you can't be vague in when a new law takes effect. But you could set it up multiple different ways. I think there might have been some question about quarter of what, state fiscal year, what's the first quarter? So you could be even tighter in terms of the state's second quarter of the fiscal year, or you could put 90 days after something occurs, right? As long as there is some way to count clearly. And that's both in terms of administering it and for taxpayers to comply.
Thanks.
Sure. You're welcome. So that was slide, I jumped ahead. On slide 11, moving on to slide 12. This gets to Representative Odie's question. Amazon in particular, because they are a large online seller, is often used as an example. Because Vermont's remote collection requirement kicked in, I think it was a year or two sessions later, Other states were enacting what are called marketplace facilitator laws because large online sellers like Amazon are often providing a platform and they themselves are not fulfilling the orders. Etsy is another example, as many small sellers who sell through this online platform. The Wayfair remote seller collection requirement law did not get at the marketplace facilitator. It was saying if you're a small seller, you have to collect if you pass those thresholds. But this larger platform would have a different, they would have multiple sellers and they would certainly be exceeding through the platform that 100 or 100,000 or 200 transaction threshold. So following on the heels of, I think Washington was one of the first states, which I realize it makes sense because that's where Amazon is headquartered, that they were requiring the platform, if they or their sellers, their third-party sellers were exceeding their threshold, they would be also on the hook like a remote seller to collect. I'm saying on the hook because they become statutorily liable to collect and remit sales tax. So in 2019, Act 46, Vermont did enact a marketplace facilitator law. And this had the same collection requirements. This is on slide 13, imposed on marketplace facilitators. So the facilitators are now required to collect and remit. And that law does have some notice requirements to small sellers explaining that they will be collecting and remitting. There are some opt-out provisions as well. And then if there is provision as well for if there's incorrect collection and remittance, that it isn't necessarily the facilitator's liability if the seller is providing incorrect information, some details like that.
Yeah.
Perhaps you'll get to this when you get to meals and rooms, but my recollection in this whole debate about intermediaries and jobbers and facilitators, there were multiple ways to value the good. That is to say, what the customer ultimately paid was not necessarily what the jobber was listing as the value of the item. And so the question is, what's the 6% or 12% on? But I suppose you'll get to that when you start talking about meals.
Perfect segue.
Okay. Because that gets really slippery in the definitional.
Exactly.
To catch those folks.
Yes. So they're very similar. There has been a similar movement in meals and rooms tax as well. And I will go over there, but two different changes in the last few years. Similarly, not expanding the tax base in this. It does expand the amount of revenues that are being taxed, but it's more in the definitions of operator or restaurant or seller, depending on the tax type. Great. So then I will move on to meals and rooms tax. That's perfect. That means this presentation is logical and is to the next questions. So looking at slide 15, the structure laid out the tax base, the tax rates, and tax liability. I'm only looking at meals and rooms tax. There is also a separate alcoholic beverages tax also within the same chapter. I do not go into much detail there, but I'd be happy to provide more information. That's had a lot less movement in terms of these bigger changes, statutory changes. So the tax base, they are actually two separate taxes, on meals and rooms. So the meals tax is on taxable meals. You don't have the same, there are quite a few exemptions, but it's all through definitional changes. So they're technically exclusions to the definition of a taxable meal. It gets confusing and complicated because of the way it's structured. It's sometimes not as clear cut as sales tax where it's a straight exemption. So sometimes that can be confusing. Rooms tax is on the occupancy and the rent. Again, the exemptions or exclusions are quite diverse. So it can be on the type of the meal, it can be on the purchaser, the seller, or the use. So one example is meals served on school premises or at camps for children. So that's use-based, but also a type of purchaser. So they are flat rates, 9%. Again, you can have a local option tax. And these are also taxes imposed on either the occupant or the person consuming the meal, so the purchaser. Moving on to slide 16. Again, these are trust taxes. They are collected by the operator or the restaurant. It's at the point of sale. These are, again, retail sales. These are not wholesale. That was actually enacted into statute several years ago, that sale for resale of a meal, for example, a caterer who is purchasing something that they will then resell to their final consumer when they're purchasing perhaps baked goods and they're planning to resell them, that initial sale is exempt, and there's now an exemption certificate process for that. It does apply statewide, and again, there's the 1% that requires a municipality to vote to impose that local option tax. So moving on to slide 17, I did try to parse out, and I tried not to go into too much detail because it gets very complex quickly and can be confusing. It's often helpful to have a real example, and I'll use bakery items as one example. So taxable meal is any food or beverage sold by a restaurant for consumption on or off premises. Because it's sold by a restaurant and there's a specific definition for a restaurant, it is taxable. Or food or beverage not sold by a restaurant and not prepackaged for consumption on or off premises. So that is your cafe where you're going and getting something warm typically, or a coffee. You're going to consume it either sitting there or you're going to drink it somewhere else. Then there's a third category of regardless where it's sold and whether or not it's prepackaged, this list of food and beverage items are always taxable. They're always considered a taxable meal. Sandwiches of any kind, except when frozen, food or beverage furnished from a salad bar, heated food or beverage, and food or beverage sold through a vending machine. Previously, vending machines were treated differently. That was maybe 2015 or 2016. They're always taxable. And then there are many exclusions. I mentioned I would give the example of baked goods. They're only exempt if they are sold in quantities of 3 or more. So if they're sold in smaller quantities, they are taxable. Different policy decisions behind this.
Representative Odie.
Do they have to be the same exact, like 3 scones, or could it be 3 different? I'm not kidding.
Could look in the regulations. It just says
I
baked
think it's
items.
the same, Carol.
I think it's the same.
Blueberry as opposed to raspberry.
I want to know.
I believe it's the same. It's single serving bakery items sold in quantities of 3 or more. So I would assume it's the same. Three blueberry muffins or 3 donuts.
But you can go through the line 3 times.
Other things like loaves of bread, those are always excluded. The actual structure for, now I'm talking about taxable occupancy in slide 18. So looking at the rooms tax. So a taxable occupancy is the tax is due on rent charged for the use or possession of sleeping accommodations offered to the public for a consideration, so for a charge. So it's only if it's actually costing something. If it's free, it's not taxable. So this does not include occupancy by a permanent resident, which is defined in this chapter as someone who is renting for at least 30 consecutive days. So a lease arrangement is not subject to meals and rooms tax. If someone is staying in a hotel for at least 30 consecutive days, that then becomes also a non-taxable occupancy. Rent is not taxable when it's an employee of an operator. So perhaps an employee of a hotel who is being housed when that occupancy is remuneration for employment. Again, any occupancy provided in a summer camp for children. Those have been carved out in several instances in this chapter. Okay, so that's the general structure. And then I do have a few slides on recent changes, as Representative Anthony just mentioned, very similar to the movement in the sales tax world, definitional changes to get at different types of transactions. So on slide 19, an operator may be a traditional lodging establishment when we think of rentals, such as a hotel or bed and breakfast, or an operator may be a property offering a bedroom in their home for a short-term rental. And there is a specific definition for short-term rentals now under statute. A hotel includes inns, motels, tourist homes, cabins, there's a long list, and short-term rentals. And with the sort of proliferation of short-term rentals, that's led to more scrutiny. There previously was the statute was interpreted as applying to them, but as there wasn't a specific definition and a specific imposition of the tax on short-term rentals that has since been added in the last few years to statute. I did note here, because all of this was public, that Airbnb in particular did enter into a collection agreement in 2016 with the Department of Taxes. So their structure is they collect under one rooms tax license for all of their hosts, all of the individuals who rent or businesses who rent through their platform. But within several years, because they are not the only platform, 2 years later, short-term rental was added to make sure that hotel clearly applied the meals tax to short-term rentals. And there was some movement around more of the health and safety side of short-term rentals. So there were some requirements in the Department of Health and I think Public Safety to do outreach to different short-term rentals. And all operators are now required to post their room tax license number whenever they are advertising for rent. And in the case of Airbnb, they just have one. But if you look at a rental ad, there's going to be their rooms tax number at the bottom to show that they have a license. Okay. And then also getting at what is actually being charged to the customer, the purchaser. There were two changes both in 2019 and 2021. The first was to add a new definition for online travel agents, so booking agents. That means that they are required to collect on their charges. All of those charges are subject to rooms tax. And I noted applied rooms tax to online travel agent charges. It's not only to online, but those just are the most common way that people are booking reservations. And then 2 years ago, taxable meal facilitators. So in the meals tax area, any meal delivery charges or meal facilitator charges, those are now taxable, and those individuals or businesses are required to collect and remit. What was happening that was not being taxed was there would be, so you'd order a pizza, it would be $20 or $25 that the consumer would pay. The restaurant would be collecting maybe $15 of that, and the remainder would be going to the perhaps delivery service, and only $15 is being subject to tax. So the taxable meal facilitator gets at the full charge that's being paid by the consumer.
At one time, not only was the operator and the underlying base issue, but also in the case of package deals. Mm-hmm. Come stay with us, you get free spa, you get to go to the whatever, or you get dinner. Because those rates may differ, is there still a problem in trying to unbundle these package deals? And fairly price or tax each of the components.
So my understanding is the final charge that's paid by the consumer is taxable.
And so it wouldn't matter what's included.
Exactly.
Okay.
Right.
Because we found when we dug into this 2 years ago, I guess you said,
19.
That there was huge inconsistencies on how it was being applied, and more communication to the consumer was also needed.
And there was I didn't note this, I didn't want to get into too much detail, but there was a movement across multiple states to litigate under the prior definitions that didn't clearly apply to the full charge, and most states were losing those lawsuits. So the choice was to amend the statutory definition to make it clear that those charges are taxable.
Does the state have agreements with other short-term rental platforms besides Airbnb, or is that it?
Not that I'm aware of that haven't been made public.
And has there been any analysis of how that arrangement with Airbnb is working out since it was
In terms of revenue, I'm looking to JFO. I don't know if
We can have Texan answer about it.
yeah.
perhaps they're better able to answer that question.
So if I order a meal for takeout and I have DoorDash pick it up and deliver it, and the meal is, and it's on the menu, it's $20. Can you just tell me who pays the tax along the way as that?
Yeah, that's a great, to give an actual example. So when the restaurant is, it depends really on how the restaurant and DoorDash, under your example, are, what their agreement is. But your actual charge would be, in theory, just paid to DoorDash, assuming that they're buying it from the restaurant. That transaction would be considered wholesale because that's not the final consumer.
Okay.
There would be no tax there. It would be owed when you are getting your pizza. You are
At the
paying
door.
at the door on the
That's-
full charge.
That's assuming I haven't ordered it online and paid for it at the restaurant and just having DoorDash deliver.
In that case, it would still be applicable to the charge that whatever your full price is that you're paying would be subject to tax. Does that make sense? If you're getting the free delivery, that wouldn't be taxable.
Okay. Maybe I don't know enough about how it works, but, so I get on the phone and I go to the restaurant and a $20 meal and they say, and tax,
Yes,
you get taxed.
and that's,
And then I say, okay, DoorDash is gonna come pick it up and deliver it.
Oh, that's not how DoorDash works,
That's not, okay, that's what I don't know.
which I didn't know until we talked about it in committee because we don't even have DoorDash in Brattleboro, so.
Okay, so there must be delivery services that say, yeah, tell me the meal, I'll go pick it up and take it to your house.
right, so if you were going through DoorDash, you'd be going through their platform, their service, and they would be charging you
But
for that delivery.
but that's, DoorDash apparently doesn't work the way that I thought it does. Because in DoorDash, I guess you're buying the meal.
Through DoorDash.
Okay, but if you're just buying the delivery service, then are you taxed on the delivery service when that guy, I've already paid for the meal. Somebody drives up and says, here's the,
Are you thinking your tip to them?
No,
That's not
just-
taxable.
I'm gonna pay them to deliver it to me.
Then that would be taxable, but I'm not sure that's how most of those work, but
Okay.
yes,
Okay,
that's part of your meal.
So we need to wrap up this part of the presentation soon, and I would like to renew my call that if anyone wants to get very, very excited about sales tax or meals and rooms tax, like there's a lot of opportunities, including the streamlined sales tax agreement, all kinds of things for like the committee members to really like embrace this detailed topic. You had
This is probably a dumb question to ask, but,
no dumb question.
for grocery deliveries, that's not taxable, correct?
That's correct, because that's food, which is exempt from sales tax. And then you get into that analysis of, is it prepackaged? Is it, more along the DoorDash pizza? Pizza is, for immediate consumption. It's generally warm.
So if someone ordered a whole bunch of pre-made sandwiches from a grocery store and had them delivered,
That would be exempt from both sales tax and, sandwiches of any kind are always taxable under meals tax unless they're frozen.
so then if they were delivered by a
So then it would,
grocery store or by one of the different delivery services that does that from grocery.
generally, those would be considered exempt because they're food.
Okay,
And they're not grocery stores are almost never meet the definition for a restaurant to be subject to meals tax. And if the other interaction there is if one of the taxes applies, the other doesn't,
okay,
you never have both meals and sales tax
weird little
ever.
one there, yeah, okay.
Yep, no, that's a great.
Last word.
Yeah, thank you. I recently, this is not food but books, ordered something from Vermont Historical Society. Two books, and I noticed the bill was tax on the books, okay, that's.
Yep.
But they also taxed me on mailing, is
Delivery,
that correct?
mailing, interesting. The delivery charge, I guess, is
It
what
was-
that is
It was
taxable.
postage.
Huh.
Postage and delivery, and they taxed that, and I paid it, but I wrote on the.
That's interesting.
I don't think this is right.
Delivery charges are taxable. I don't know if that means postage, though. That's an
Yeah.
interesting
No,
take on that. I'm not sure.
I just kind of wondered, and I'm not
Back to you.
disputing it, I just was trying to figure out what. And
And
anyway,
shared, I also challenged once something on sportswear, but then realized it's actually not generally used by anyone. If it's very specific to biking, for example, it is taxable.
Because it's not clothing.
Their clothing, right? I said, oh, they're right. I do it.
Thank you.
Thank you. Sorry to take so much time.
No, it's not you, it's us, and that's why we're here.
Morning.
Morning.
For the record, Emily Byrne from the Joint Fiscal Office. Going to do a similar presentation that I've done, sort of piggyback off Abby's, show some numbers, talk about the 6 principles and thinking about sort of big picture and consumption taxes. This again is focused on sales and use and meals and rooms. We have a little bit at the end on taxing of software as a service, just as a I don't know, hint at it, I guess, but definitely more conversation will be had about that. So I'll jump right in. I'll go right to slide 3 on the sales and use tax. So as Abby talked about, 6% charged on the retail sale of all personal property unless it's exempted. There are many exemptions. I'm not going to steal Pat's thunder. Pat's also here with me. He's our sort of consumption tax estimator. He's in charge of all that. And he is going to present the tax expenditure report. So he'll go into much more detail on the individual tax expenditures, the methodology for estimating. But we estimated there was about $302 million worth of sales tax expenditures in FY 2021. I have a chart at the end that shows more detail on that.
An expenditure is the money we don't make.
Yes, correct. So that is when we make a decision. Groceries are not subject to the sales tax. This is our best estimate of what was not collected as a result of that decision. So the next bullet, right, the difference between an exemption and non-tangible personal property. An exemption is when you exclude things specifically from the tax base, medical products, groceries, newspapers, clothing, a whole bunch of those things. Non-tangible personal property is things like services. We don't exempt services explicitly. They're just not considered personal property, which is why they're not subject to the sales tax. There are 20 municipalities that have the 1% local option sales tax. And the list is out on the tax department website if you want to see that. And it is 100% of the sales and use tax is allocated to the general or to the education fund. It used to be split between the education fund and the general fund, and that was changed in 2018. The general fund transfer to the education fund went away. Go to slide 4, you can see a history of sales tax collections in Vermont. In the 3 light green bars at the end I updated them yesterday based on Tom Cavet's new forecast for sales tax receipts for the next 3 years. I mean, you can kind of see that little dip, that sort of soft landing he talked about in 2024. Sales tax will have a little bit of impact as a result of sort of they think the economic conditions are going to look like next year. Generally sort of a picture of it. We've had some good Wayfair is in there, some of those other changes. Slide 5, this is a table that I've shown you before, but this is the state sales tax rates, right? Doesn't include the local option taxes or any other local taxes that other states have. But at a high level, we're in the ballpark of where other states are in terms of their sales tax rate, their state sales tax rates. I have a couple similar slides on the meals and rooms tax. So meals tax, 9% on prepared foods in restaurants and bars. Tax expenditure report outlines 8 exemptions to the meals tax, totaling an estimated $9.6 million in 2021 of foregone revenue. Rooms tax is 9% on room rentals, including meeting rooms and hotels. Tax expenditure report outlines 6 exemptions, and we don't have estimates on those because they are small. So the exemption on, Abby gave the example of summer camp spaces. There are a lot of summer camps in Vermont, but the rooms tax estimate, like what the rooms tax would be on those spaces is not enough. We don't have enough data or don't really have the ability to estimate. So they're very small tax expenditures on the rooms tax. There's the 10% alcoholic beverages tax for alcoholic beverages served in restaurants and bars. There's 25 municipalities have a 1% local option meals and rooms tax. Little asterisk, Elmore only has it on the rooms tax. They don't have it on meals. And Burlington and Rutland administer their own local option meals and rooms taxes. They had them prior to sort of state laws on this, so they're allowed to keep doing their own thing. And the meals and rooms tax is split between 3 funds. Split between the general fund, the education fund, and the Clean Water Fund. We look at slide 8. Similar to the sales tax piece, the sort of lighter shaded bars are the forecast from yesterday. You can see, a dip in 2021 when COVID hit and people were not coming to visit, people weren't moving, people weren't coming to visit.
Yeah, Brooks.
I have maybe, they're not predicting a dip in the rooms and meals tax, like the sales tax. In the report yesterday, did they indicate why that is?
Trying to remember if they went into that detail.
Yeah.
I do know historically, meals and rooms tax tends to be okay during a recession
Okay,
because
historical then.
historically people will still be some travel. People may go out to dinner less, but the alcoholic beverage tax may go up during recession. So there's some sort of, there's some things that get modulated. So I think it has a little bit less, it's a little bit less
Less impacted by.
impacted, yes. It's really more, and I'll get into this a little bit, but like, it's nice. We used to joke when I worked in the budget office of like, oh, I'm glad it snowed in Boston last weekend because people will come here to ski, right? Like it's more subject to those sorts of things than it is sort of general economic conditions. Slide 9, table we've looked at before, sort of the comparison across the Northeast states of rooms and meals tax rates. Again, doesn't include any local taxes, right? New York City, we know, has a big rooms tax. At the city level, and our rooms tax is right in the ballpark of some of our neighbors. Other consumption taxes, there are lots of other consumption taxes, and I didn't go into detail on a lot of these because there are people at JFO that know more about them that would be better to hear from. I think if you want to hear more about like motor fuel taxes, gas tax, diesel tax, purchase and use tax, it'd be good to have Chris Roop come in and give that overview. He's the analyst for the transportation committees. And those usually fall into the transportation committee jurisdiction. And given the sort of conversation we had yesterday about the status of the 3 funds, it is the T fund. That's the one that sort of is probably going to need the most examination in terms of potential changes. And Ted will be in at the end of the week to talk about cannabis and the sales and excise tax on cannabis. The healthcare team, probably the best to talk about the provider tax and the premium, insurance premiums tax. Then there's other little ones, fuel taxes, solid waste franchise tax, et cetera, that are out in the world, but are a much smaller component of state revenues. We'll go through the 6 principles and sort of how to think about sales and use and meals and rooms and other consumption taxes through that lens. So always we'll start with sustainability and reliability. So sales and use does have some impacts when there is a recession. If people have less purchasing power, then they are likely to buy less things, thus impacting the sales tax receipts. Similarly, with inflation, Tom talked about this a lot yesterday, right? Prices are up, which means 6% gets you more sales tax revenue, which is good, except for when you think about the sort of whole state financial picture, that's only one side of the equation, right? Yay, sales tax revenue is up because of inflation. But inflation will come on in the back end, right? And impact the state budget. So it's balancing those sort of inflationary impacts. The demographic impacts also come through. We talked about them with the personal income tax and sort of how income changes as you get older, but similarly, people's purchasing habits change as they age. Younger people tend to purchase more goods, so things that are subject to the sales tax, whereas older people tend to purchase more services. Those are not subject to the sales tax. So as the population ages, there's a potential impact on the sales tax trajectory as a result. And as there's been a general shift to a service-based economy in Vermont, in the United States, and as people start to spend their money more on services than they do on goods, there's an impact on the sales tax in terms of percentages of people's income that are going to tangible property versus not tangible property. Meals and rooms, we've talked about this a little bit. Tourism is really the significant driver behind the meals and rooms tax.
It's estimated that about 50% of the meals tax revenue and the vast majority of the rooms tax revenue are as a result of tourism. So conversations about like, how's the ski season going is going to impact the meals and rooms tax. Whether or not it was a good leaf year. Got a lot of people to come up and check out the leaves and stay in the rooms and have dinner. Those are sort of the bigger drivers of that. Or the things that can impact sustainability and reliability of meals and rooms that are really out of the control of most of us. From a fairness perspective, we talked about this, but the consumption taxes are generally regressive. So from a vertical equity, it's blind to your ability to pay. We know that younger and lower income households tend to spend a greater percentage of their income on goods. So they are paying a higher percentage of their income in sales tax than other folks. But from a horizontal equity perspective, everybody's paying the same rate, right? We're all paying 6%. We buy, I can't even think, if you buy a bicycle, everybody's paying 6%. You buy the same bike, everybody's paying the same 6%. To try to account for the regressive nature, right? This is where the sales tax exemptions come in. So trying to exempt things that lower income folks tend to spend more money on, exempting them from the sales tax tries to make it more regressive than it is if it was just a flat rate on everything. Simplicity, the exemptions from the sales and use tax, can make it more, can make the system more complex. Abby talked about the streamlined sales tax agreement, joined in 2007. There are 24 states, so almost half the country is a member of the streamlined sales tax agreement. And it is all about sort of standardizing the definitions for products to make it easier for businesses to comply. But within those standardizations, right, you get the complexity, right? So we've talked a lot about, I put the definition of candy per the streamline agreement in here, right? Like, okay, so it can't go in the refrigerator. It can't have flour. So I think that, right, that's how you exempt those like Snickers, ice cream bars from candy, right? Those sorts of things. And then I pulled the definition of tobacco as well. Yeah.
Does streamline apply to clothing as well?
Yeah, so there are definitions of clothing.
It does, okay.
Yeah.
Thank you.
There are definitions for everything, I think.
Okay.
And it's really, Abby can correct me if I'm wrong, but it's really, if you opt for something to be exempt, you just have to adopt the definition of streamlined. Or if it's in, you adopt the definition of streamlined, but it's up to the states to kind of determine what's in and out.
Okay.
It's just sort of adhering to those definitions. And Abby talked about this a little bit, but there's some complexities around the sort of point of sale issue, right? If a contractor buys lumber for a house at Home Depot, are they the final consumer? Or is it the person who's paying the contractor the final consumer? And how do you sort of manage that? It can get pretty complex in terms of those as you move through the supply chain. On slide, what's the answer to that? The answer to that? That's an Abby question.
Sorry, 1 second.
One quick question. I noticed under tobacco, there's not any reference to like vaping or e-cigs. Is that a totally different category?
That is a good question. And I don't know anything about e-cigarettes, so I don't know.
Abby has spent some time thinking about it.
Yeah, sorry, what's the slide that you're on?
Slide 16. I grabbed the definition of tobacco from the streamlined agreement. It doesn't talk about e-cigs.
Yes, so retail sales are subject to sales tax.
Got it.
But then you also have a whole slew of wholesale excise taxes, depending on the type of the product. Vaping in particular does have other taxes imposed wholesale or resale. That's other tobacco products tax.
Okay.
Oh, yeah, it's making.
Happy to provide more if you want.
So on slide 17, this is from the tax department website. This is what is considered exempt clothing, and this is what's taxable clothing. I think my favorite one is that if the belt buckle is attached to the belt, then it is exempt from the clothing tax. But if you buy the buckle, just the buckle, then it is subject to the sales tax. So, right, those complexities are in there. But I thought this was just an interesting. They've got a similar thing for some of the other things. I was like, okay, so is this in or is this out that you can look at? their website. From an economic competitiveness perspective, we hear a lot about this, a lot of the cross-border concerns, since we are close to several other states. And it's easy to get from one state to the other. Our sales tax rate is generally below the Northeast average, but being New Hampshire's neighbor, they have no sales tax. So like, I know that I've gotten into the situation where like, oh, they have no sales tax, but like, oh yeah, we don't tax clothes either. So like, yes, they don't have sales tax, but we have exemptions on things. So just trying to understand all those things. And so to that end, right, comparisons across states is difficult because we exempt certain things that other states do, or other states exempt more things, et cetera. So kind of comparing can be tricky. And on the meals and rooms side, we have to think about what's being purchased from an economic competitiveness perspective, right? Can't really move the ski hill or move all the maple trees, right? So, thinking about that when setting rates, which I think is why you see a lot of cities with some pretty high lodging rates, because there's only one Empire State Building, right? So on some level, if you want to see it, you're going to pay the New York City rooms rate, right? Because it is what it is. Or you may stay in New Jersey, but maybe not. Tax neutrality, there is probably some behavior influence that happens within the sales and use tax, right? So people making decisions about where to go to purchase things as a result of sales tax. And I know there's lots of conversations about whether or not to impose the sales tax on soda. And sort of, will that change people's behavior if there's a change in price in soda? And is that one of those sort of policy goals, right, to get people to drink less soda? So impose the sales tax on soda, drive the cost up, or not? Meals and rooms tax, some of the stuff that Abby talked about with the addition of short-term rental to the definition has sort of gotten that moving towards some of those tax neutrality, right? Like prior to that, staying in an Airbnb meant that you didn't have to pay the rooms tax. Now they're sort of subject to all of those things. So there's a lot less the base has gotten bigger and you can't really avoid the meals and rooms tax. And then the last one, accountability. I'm not going to steal Pat's thunder because he's going to do the tax expenditure report next, but it came out, we posted it yesterday. Pat worked all summer on it. Estimated 300 million in expenditures in sales and use tax expenditures in 2021. The goal of a lot of them is to increase the progressivity in the sales tax, as we've talked about. Meals and rooms, estimated 9.6 million in 21. And there are exemptions for food serviced by schools and grocery type items furnished for takeout that are trickier to estimate, but are outlined in that report. The next one is just a snapshot of that $302 million in the exemptions for sales and use tax. Sales of food is over a third. Yeah, over a third of the sales tax expenditure. And then clothing and footwear and medical products come in behind that as sales tax that we do not collect because it's exempt from the sales tax. And then real quickly, I will briefly touch on applying the sales tax to remotely accessed software, which is sometimes referred to as the cloud tax. So currently, items that are software as a service, platform as a service, and infrastructure as a service, there's some examples listed on the slide 23. Those are not subject to the sales tax. The question, I think, for policymakers is whether or not it should be. We've done some preliminary estimates on what we think if those were included in the sales tax base. It's approximately $18 million for a full year's worth of sales tax collections. The estimate that we did in the spring was about 16.8. So in 6 months, we've updated that estimate by not $1 million and change. But it's sort of showing that there's a lot of growth in that industry, a lot of growth in people purchasing those things. And it may be, it may be a place to look for resources. Want to caveat, this estimate is based on the sort of historic bills. So if there are changes to what was in and out of the base or anything like that, that would change this estimate. The first time JFO did an estimate of this was in 2013 and it was about $5 million. So there is continued growth. Yeah, so that was 10 years ago in this space. And
this isn't expanding the base, this is repealing an existing exemption within the base.
yes, yeah. It's a good clarification. But I do think Abby it gets really complicated really fast. So I think it would be, if this is something that the committee wanted to pursue or continue having conversations on, I think requesting the full legal picture, and we can do more scrubbing of estimates.
Emily, can you just clarify that 18.4 million? Is that that's the projected tax expenditure, or that's the projected amount spent in the state annually on?
Tax expenditure.
That's, okay.
Yeah.
Oh, interesting.
So how much we lose by
Yeah,
not collecting.
right.
Divide by 0.06.
Yeah.
Yes, and I'm sure everyone knows that we will have more opportunities to discuss all of these issues.
On slide 21, Emily,
Yeah.
all others, does that include businesses that are tax exempt? Or is that a separate category?
Does that include that?
We can get into that.
Okay. Oh, yeah, I should have waited.
Let Pat talk about the exemptions.
Got it.
Great, thank you so much.
Yeah. All right.
You might call anyone who's really excited about the streamlined sales tax. So we are going to take a brief break. Sorry to cut into your time there.